Good afternoon. This is the House Judiciary Committee. We are presently being recorded and available online on the Maryland General Assembly website. It is the 24th of January, and we are hearing three bills today, beginning with Delegate Edelson's bill, House Bill 207. Who else do you have? You have, okay, come on up. That's fine. And do we have anybody virtually?
Yes.
All right. Oh, it is his first time in this committee. Members should act appropriately.
Appropriate
right,
appears to be different for every committee.
That's fine. We have, this is a bill of first impression, so 3 minutes for the sponsor, 2 minutes for everybody else. Go right ahead.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, congratulations again, and members of this esteemed committee. For the record, I'm Delegate Mark Edelson in support of HB 207. In 2019, this legislature passed a Vision Zero bill. The law set a goal of zero motor vehicle related fatalities or serious injuries by 2030. According to the MVA Fatal Crash Dashboard from 2019 through 2022, we had an average of 517 fatal crashes on our roadways and 29,000 injury crashes. In 2023, we had 597 fatalities, of which 167 were pedestrians or bicyclists, vulnerable road users. Of these deaths, 224 were the result of speeding or aggressive driving. That is nearly 40%. Non-motorist traffic fatalities once comprised 1 in 5 of all traffic deaths. They're now 1 in 4. As we know, speeding and aggressive driving not only increases the number of crashes on our roads, but also increases the severity of crash outcomes. What you might not know is that a pedestrian or bicyclist struck by a motorist driving 40 miles per hour is 8 times more likely to die than a pedestrian or bicyclist struck at 20 miles per hour. Over the past year, I have met with neighbors and stakeholders from around our state who need us to do more. Some of them have loved ones that have been victims of these crashes. I know we all remember the horrific deaths of 6 construction workers on the Beltway last year, including a father and son. HB 207 is an attempt to do just that by modifying the penalties for reckless and aggressive driving. Reckless driving is the operation of a motor vehicle in wanton or willful disregard for the safety of persons or property. Aggressive driving is the commission of 3 or more specified traffic offenses at the same time or during a single period. The current maximum penalty for either of these violations is a fine and points on one's license. Every year, there are approximately 14,000 to 15,000 citations issued for reckless or aggressive driving. We are clearly not doing enough to prevent these fatal crashes from happening in the first place. We are also not in line with 41 other states, including DC, Delaware, Virginia, and West Virginia. In order to make our roads safer, I am proposing that the state increase penalties for aggressive and reckless driving. HB 207 would provide for up to 30 days of jail time for a first offense and up to 90 days for a second or subsequent violation within 3 years of a prior conviction. Vision Zero is a goal we should all be striving for. It is going to take a multifaceted approach to get there, and I believe that this bill is one piece of that puzzle. I would ask this esteemed committee for a favorable report on HB 207.
Good afternoon, everyone. My name is Brian Thompson. I'm one of Mark's law partners at Silverman Thompson. I am a former prosecutor, and I've been practicing criminal defense exclusively for the last 25 years. In Maryland, there's really only 5 categories of crimes that you can commit while behind the wheel that can result in potential incarceration. The first 3 are easy: DUI, fleeing and eluding and leaving the scene of an accident. Obviously, those all implicate public safety. But the last 2, driving an uninsured vehicle or driving on a suspended license or without a license, they're administrative crimes that don't implicate public safety. And just to illustrate, if you forget to pay your insurance premium and get on the road the next day and get pulled over, you face a potential of a year in jail. I'm not saying that that always happens, but that's the maximum penalty. Or if you're get a little behind on your child support and they suspend your driver's license and you're on your way to work, you can get a year in jail. But you can drive the way Malaki Brown and Lisa Lee, who are the people who killed those 6 construction workers, two of whom we represent. They were clocked at 118 miles an hour on 695 in traffic. Now, before you all passed the bill in 2021 CR, it's the CR 2212.1, which is driving in a criminally negligent manner, causing life-threatening injuries. Even if all those people had been maimed, Malaki Brown would have been facing no jail time unless someone was killed. So there's 41 other states, as Mark said, that criminalize this obviously criminal behavior. We all drive on these roads. We all see how a very small fraction of people drive. It seems to me that it's gotten much worse since COVID for whatever reason. There were fewer cars on the road or whatever reason. But to me, it makes a lot more sense to start trying to deter this behavior before people get maimed or killed. And passing this bill, I think, would do that. Lastly, the other part about this is if there's no criminal penalty, no incarceration, then there's no prosecutor in the room. So what that means is we've all gone to traffic court, cop doesn't show up.
Couple more seconds, please.
Case dismissed. There will be prosecutors in the courtroom that can work these cases up and use their discretion to prosecute the most egregious cases. Thank you.
All right, do we have our virtual?
Hi, good afternoon, committee. My name is Christine Taka. I'm an assistant state's attorney with the Baltimore City State's Attorney's Office. I'm here on behalf of the Baltimore City State's Attorney's Office in support of House Bill 207. I'm a prosecutor in the city, and I prosecute incarcerable traffic cases on a regular basis. Reviewing House Bill 207 helps bridge the gap, as the delegate and Mr. Thompson had indicated, with regards to punishing unsafe driving, in which doesn't involve alcohol, doesn't involve fleeing from police. However, we have this gap in the transportation article that people are driving aggressively and unsafe and subjecting it to the rest of us on the roadway. And yet, from a prosecution standpoint, we have no tools in our toolbox in order to help sanction that bad behavior. With passing of this bill, I believe that it would help prevent the behavior and give the state's attorneys throughout the state of Maryland a tool in their toolbox to help sanction that behavior and make the roads safer. For those reasons, the Baltimore City State's Attorney's Office is in support of Bill 207, and thank you very much for this opportunity to address the committee.
Questions from the committee? Delegate Cardin.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill, and it's good to see you, Brian. It's always good to see you. For those of you who don't know, just one of the best criminal attorneys out there. It's a joy to watch you practice.
Thank you, John.
One of the first things that a judge does or wants to know when I'm at a DWI hearing is, was there an accident? Was somebody hurt? And if there wasn't somebody hurt, usually there's a lot more leeway that the judge is willing to give. And the question here that I have is, in this case, if you have somebody who might be charged with both aggressive driving and reckless driving, but there was no accident, shouldn't we be allowing shouldn't we have basically some different levels, or should that all be under the discretion of the judge? And I'm wondering whether maybe we take a baby step in this case versus going the whole way and giving the judge full discretion to potentially give jail time, when certainly and I'm a bicyclist who I've been knocked off the road, thank God, not by somebody going more than 40 miles an hour. And I know that I think that person should face jail time. But if somebody just, is whizzing through and then gets pulled over and didn't cause any accidents, I'm just curious to know what you think, whether we should just open it up for full discretion or start slowly.
So, I'm happy to let the prosecutor respond, but my thought would be the purpose here is to be preventative. So the idea is that the statute would reflect up to 30 days on the first offense, right? So there's obviously discretion to have it be 0 days, 29 days, 30 days. So that would be, a decision made by the advocacy of the prosecutor and ultimately the judge. The issue is that if we take more of a baby step, we're basically going to be where we are right now, which is the maximum penalty is a fine and points on your license, resulting in nearly 600 road deaths last year. And so I think the issue here is if we don't take a much more intense step, we're not going to be doing everything we need to do to keep people safer on our roads.
I answer too?
Sure.
Okay. John, may I throw 2 cents in? In my mind, this is a baby step. Again, you can go to jail for a year for driving while suspended. You can go to jail for a year for driving while uninsured. Those activities, I'm not condoning them. They're illegal, but they don't endanger anybody. This is a maximum of 30 days, unless you're dumb enough to do it again, or just crazy or callous enough to do it again within 3 years. Then you could face 90 days. Also, the benefit of having the prosecutor in there, and I was in court with Chris this morning. She's been doing this for a long, long time. The prosecutors would then say, all right, this case isn't a super egregious one, so we're not going to seek jail time. That's what prosecutors do. And if there is a super egregious case, where say someone's doing 118 miles an hour, I live in the county, I drive to the city every day where our office is, and people are racing on 83, literally drag racing, passing on the shoulder. And just because no one gets hurt that time, it's only a matter of time. I would sort of equate that as saying, well, I took a shot at the person, but the bullet went over his head. So, hey, no harm, no foul. So in my mind, this is a 30-day max is a baby step for this incredibly dangerous behavior.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill. This interim, I had several conversations with driver instructors for the profit entities, and they've been concerned about aggressive and reckless driving as it relates to persons that maybe are foreign, and then there's a language barrier, but not having to go and get the driving instruction and things of that nature. I guess my question is, in this bill, or do you think that it's necessary to also add the part of going back for training, for some type of instruction to address some of this reckless behavior? And some of it's due in part to language barrier and also understanding fully our laws on how to handle things on the roadway. That's the one part I kept hearing from the instructors. And then the second item, have you had a chance to speak to Maryland Association of Counties? And I only raise that point because if these persons are incarcerated, the county incurs that cost. So with the 30 days that you're proposing and, beyond, that would be a county expense. So I was just curious if you heard anything from the county representation.
Okay, so yeah, so thank you so much for those questions. To your first one, I think that having an aspect of somebody, doing a training program, some kind of speeding program, if they're convicted, is an excellent idea. My thought is that would be better left to the communications between the defense attorney, public defender, and the prosecutor as to part of the discretion that can be applied here as to whether or not to do 1 day, 0 days, 30 days. My fear would be if we start to put all of that as a requirement in the bill, I'm just concerned about overcomplicating the bill. My thought was here to keep it as simple as possible, as in, increase the penalties for these particular offenses and not impact the rest of the statute. As to your second question, we did reach out to MACO on the bill, and they ultimately reached out and said they weren't going to be taking a position on the bill. So,
okay, thank you.
May I respond real quick, Tim? So we're not really talking about behavior that people don't know is not correct, right? The statute is wanton and willful disregard for the persons and property of others. The folks that are driving like this know very well that they are violating the law when they're doing it. But to Mark's point, judges order people to take the driver improvement program all the time. And that's the kind of thing I would think would be appropriate for the least egregious of these cases, or people with very clean records. And as John said, people that didn't get hurt. Maybe those kinds of, and judges are trained to do that. Prosecutors are trained to do that. We work these kind of cases out in court every single day, but we're really trying to get at behavior that is, again, we all see it on the roads. I don't need to explain. This is not someone that doesn't understand that they're not allowed to pass on the right at 100 miles an hour.
Thank you, Mr. Chair. Thank you for bringing this bill. My question is for the state's attorney or the representative from the state's attorney's office. Hi, do we have any data with regard to the age ranges of the most, the folks that are considered reckless driving? Are they mostly 16 to 20-year-olds? Are they 20 to 25? Do we have any data that indicates that it's mostly our youth violating these rules?
I wouldn't be able to say that because what's interesting, and Mr. Thompson has brought this up, that until you make these two crimes incarcerable, the state's attorney's office is not involved. So unless they break another law in the transportation article, like an alcohol related offense or fleeing from police, or as Mr. Thompson indicated, driving suspended or driving revoked or driving without a license, we're not in the courtroom. So we don't, I see those cases in relation to the alcohol related offenses or the incarcerable offenses. But if it is just this and of itself, we're not involved. So we wouldn't be playing a party to it. So I apologize. I wouldn't be able to have the data. I will say that in the area in which I see, for example, somebody who's driving without a license and is driving in this unsafe, aggressive behavior, since COVID, it has the gamut of people, to be perfectly honest with you. Like Mr. Thompson had said earlier, I don't know what changed in the mindset of the drivers after COVID, but it was like the wild, wild west out there and people taking their liberties with driving. But so unfortunately, I don't have a number for you, but I will say once it comes into what we call our incarcerable courtroom, it does reach the gamut. I couldn't say that it's just youthful drivers or, a particular age group.
There's somebody else that might have that.
So just to give a little bit of context as well, on the Governor's Office of Crime Control and Prevention website, the GoCab website, there is a traffic stop data dashboard that has a particular race-based breakdown, and that I believe also has an age category on it. So you can see by year, by month, by jurisdiction, it's pretty much uploaded in real time by MSP to GoCab, and then they, take out any sensitive information and put it on the website. Breakdown of by jurisdiction, by month, by citation as to the individuals throughout the state that are being cited on any different offense that's on the website. Now, one note I would make, which is as part of this bill, I've also reached out to the folks at GoCab because one of the categories that they have a reckless driving category as a breakdown. They don't have aggressive driving. One of the reasons for that is that aggressive driving happens so much less frequently because you have to be violating 3 of the traffic statutes at the same time in order to be pulled over for it. And so typically MSP isn't going to wait until somebody's violating all 3. They're going to pull them over for something beforehand. So while we have around 14,000 or so citations a year, only about 1,000 of those are aggressive driving. The overwhelming majority are reckless. But I still think it'd be important for us to have that information. So I've reached out to GoCab to see if we can have an aggressive driving aspect on the GoCab website, but that'll answer a lot of your questions, Delegate.
Thank you.
So I can tell you just anecdotally, because even though there's no incarceration, a lot of times these folks that are charged with these serious offenses don't want to lose their licenses, so they'll hire people like me to go in and defend them. And if I can step back to not having a state's attorney in the room, that means that a very often young police officer with no legal training is standing at the table by themselves and trying to go up against a seasoned, experienced criminal defense attorney who knows, ways to try to get around these types of statutes. If you have a prosecutor in the room, I can tell you Taka beats me pretty much every time. So it levels the playing field.
Thank you.
Thank you.
Thank you, Mr. Chair. Thanks for being here today. So can you explain to us the circumstances around the crash on 695?
Well, we represent. Do you want me to?
Yeah.
Okay, we represent two of the people, and the families obviously of two of the decedents. And they are Malon Simmons and his son, Malon Simmons III. There's cameras, you can actually find it on the internet. There's cameras that show the two cars, whether it was a prearranged race or just kind of a road rage thing, cutting each other off, zipping in through traffic, definitely committing both of these offenses. And then Malaki Brown was in the front. I'm sorry. He was in the right lane. Lisa Lee was trying to pass him on the left, and Malaki Brown cut over, clipped the back of the car, and flipped her upside down. And it happened just because of serendipity. There's the gap where the trucks go in and out of, and apparently that's supposed to be blocked off by a truck, and that truck wasn't there, and that's what happened. Malaki Brown was not under the influence of drugs or alcohol. Lisa Lee was under the influence of prescription drugs, which it still can be a prosecutable offense, but as Ms. Tacka will tell you, it's a lot harder to prosecute these types of cases when they're on prescriptions prescribed by doctors.
Yeah, so the first point that you made, the variance in the speed limit is really a huge dependent on whether there's a fatality or not. And when they have these kind of things, they recommend you narrow the road, you isolate the workers, you put an island. It's the same principle for a county or state road. And there are these cases, we do the right thing and then we see a fatality regardless. So this is really more about these cases where there's a behavior that frankly, we did everything we could. And because you have these serendipitous cases, you need another way to get at this. Is that kind of what I'm understanding?
Speed kills, right? And it really, the case law in Maryland says that speed alone really can't be reckless driving. There has to be an additional act of negligence. So this is not going to get to the person who's on 95 at 1 o'clock in the morning, completely sober. There's nobody on the road and the person's driving 90 miles an hour. That's not going to be a reckless driving citation. It's going to be a speeding ticket. This is to get at the egregious behavior that, again, we all witness every day. But yeah, speed's the most important factor. If they hadn't been driving that fast, I'm guessing that this wouldn't have happened, or the consequences would not have been as extreme.
Okay, thank you.
Thank you. Thank you, Delegate Edelson. And I would ask you what you think of your district mates, but I'll do that offline. My question is, my serious question is, and I mention them because I like to give the sponsors a chance to respond, and they oppose a lot of bills. The Office of Public Defenders is opposed to your bill because they say that essentially that it will increase racial disparities for African-American men who have such a hard time after being incarcerated. And so what I wanted to know is, have you had a chance to read their testimony? And is there a way that, and I support your bill to be clear, but is there a way that we can, strategies you think we can use to not pass your bill, but not widen racial disparities within the prison population? Because I think they're already too wide, to be honest with you.
Thank you for the question. I have read the testimony. I think it's an excellent point. And that is the challenge that we have when we propose any kind of legislation that could increase penalties. We have to be very cautious to make sure that it doesn't overly disproportionately impact one particular group that has already been so negatively impacted by our current incarceration system. So I think it's a very important point to deal with. I think that for us on the front end, a way that I've been thinking about dealing with that is by having an annual report from the GoCap website. I mean, I don't know if anybody's been onto the dashboard, but it is very, very easy to digest information about exactly the citations being given out every year, and what they are based on, and what it's a race-based dashboard. That's the purpose of it, for us to be able to ensure as a legislature and frankly as the executive branch as well, that they can ensure that we're not overly incarcerating anybody, but certainly African Americans. And so, you know, I think if we have that report on an annual basis, that allows us to hold MSP and prosecutors in our criminal justice system accountable to ensure that, you know, a well-intentioned bill does not end up unintentionally impacting one particular group of our neighbors.
Brief follow-up, if I may, Mr. Chair. Just simply, Delegate, thank you. I was unaware that that existed, that database existed until you mentioned it a few minutes ago. And we hear a lot about racial disparities, which are very important. But would you please send me the link to the latest report so I can review it? Thanks. Because I didn't know it existed, that dashboard.
Yes, absolutely. Be happy to, Delegate.
Further questions for the panel? Delegate Eric.
Thank you, Mr. Chair. Thanks for being here. So on the dashboard, we found it. Were you referencing the race-based traffic stop data dashboard?
Yes.
That's a specific one?
Yes.
Okay. So it says here the median age is 39 for traffic stops, but how, I'm not sure I see a way for us to sort of figure out specifically like this exact topic. Because you have is there another thing I'm missing on this, or?
I mean, I don't know if now's the appropriate time, but I'd be happy to show it to you and you can break it down by different offenses.
Yeah,
and
I
so
think
then
a
you
couple
can
of us
see.
might want to
Sure.
dig a little deeper. That'd
Yep.
be great. Thanks.
So very quickly, the number of violations in district court and circuit court combined for reckless driving last year was 13,000 and change, it looks like. Yeah, right about 13,000 violations. So with this bill, you create a 30-day penalty. Does that make all of those violations subject to receiving the services of the Office of the Public Defender?
Yes.
So that would increase the workload for the Office of the Public Defender significantly, correct?
Yes.
All right. I noted in the fiscal note that the number of convictions, though, is dramatically less, where there were 79 circuit court convictions and 508 circuit court convictions. And I think that commonly people think you're only charged with reckless driving, not charged with anything else. But it's more common, looking more to the practitioner, that the reckless driving charge is included in other charges, especially usually drunk driving, usually the 902 A and B. Is that right?
Yes. And I mean, I don't want to speculate. I'd probably let Brian speak to this, but I suspect that it's also because not that many of them are resulting in convictions.
So yes, definitely you see it a lot with DUIs, but you also see it a lot where police officers charge it when it's really just a speeding offense.
Mm-hmm.
And then if there's an incarcerable violation, a prosecutor will typically say, well, this doesn't meet the criteria of reckless driving, so we're going to dismiss it and we're going to go forward on the DUI, or just let the person pay out the speeding ticket. If there's no incarcerable violation, then that's the scenario where I said that you have a police officer there without an attorney standing next to him or her to help prosecute the case, and the defense attorney or the defendant has a defense attorney. A lot of times police officers charge reckless driving based solely on speed, and it doesn't apply.
But going back again, there'd be a large number of public defenders that would be necessary to cover the cases that are not covered by the private bar, correct?
Sure.
Okay. It's just not reflected in the fiscal note, and that's a concern, at least to me. Another question I have: how many points does reckless driving carry?
8.
I don't know, 100%.
6.
Six. What if that just was increased to 8? What would the difference be? What would happen?
In my view, nothing.
So their license would be suspended at 8 points as opposed to 6 points when they have to participate in the driver improvement course, correct?
If they were convicted,
According to the law.
if they were convicted and didn't get a probation before judgment, sure.
Okay. But if you're looking for a deterrent, is another way forward to look at suspending their license as opposed to incarcerating them?
I can tell you that suspended licenses, and I think Ms. Tacko will agree with me, don't deter very many people from getting on the road. What deters people from bad behavior is the threat of losing their freedom. And let's be clear here. A first offense a DUI, as Delegate Garden said, unless there's a serious accident, no one goes to jail for a first offense DUI. And the same is going to be true of aggressive driving, which most prosecutors and judges consider less egregious than getting on the roads drunk. And it may be because of the lesser penalties, but very, very few people for first offenses of these kinds. And again, I've been doing this for almost 30 years. Almost no one goes to jail for first offenses. Very, very many get PBJ, probation before judgment, which means that there's no points at all. So there's really nothing other than a fine. But I don't think increasing it from 6 to 8 points would do much of anything. And even if it goes from 6 to 8 points, you don't automatically get your license suspended. You can appeal that to the Office of Administrative Hearings, and more often than not, they will give you some sort of warning on the first offense. So this is not going to incarcerate first offenders.
Delegate Carden for a second bite.
Just actually, this is maybe for you, Mr. Chair, but let me, and Mr. Thompson, if somebody has an 8-point offense and their license is suspended and they appeal to the MVA and the MVA does not grant them or a PBJ, they retain their suspended license. Then they go out and drive again and get caught. They're probably going to jail, or it's now a jailable offense. Is that
It's
correct?
definitely a jailable offense.
So it's basically if we increased the penalty to 8 points, we're basically giving them a one bite at the apple opportunity not to go to jail, but they have to, in order to do that, they have to stop driving. Is that fair to say?
I mean, in theory, but that's just not how it's going to work. I mean, the first offender is going to get a PBJ, or the prosecutor is going to reduce it down to a speeding ticket or something like that, or go forward on the DUI, because that's always been the priority. So it would be a second or third offense by the time you end up getting to the MVA.
Okay.
And again, in my mind, the point here is to try to prevent things like what happened on that tragic, it was March 23rd. I know that because it's my birthday, so I remember the day. Prevent those things from happening before they happen. And again, this is not going to get to the casual speeder. This is going to get to the folks who were driving the way they were on that day.
Thank you.
Delegate Grammer for a second bite. Anybody else get any ideas?
For a very small second bite. So it seems like a big part of the problem is not having a prosecutor present in these
Yes.
particular cases.
Yes.
Is there any other way? Is that the purpose? The majority of the purpose of the criminal penalty is to have a prosecutor here? Because frankly, even if we pass this, I don't see many of these cases being assigned to criminal penalties. Is that the importance here is the prosecutor in the room?
Right. And my guess, and I'll let Ms. Taka answer that. My guess is these cases would be pre-screened by the unit and very often dismissed. If the aggressive or reckless driving statute didn't apply, they would dismiss it and send it back down to a non-incarcerable docket. But yeah, the point of having the prosecutor is to say, this is the egregious case, and we're going to punish this case, the egregious case, to send a message to the community that if you drive like this, you're not only going to possibly lose your license, but you might lose your freedom for a little while.
Would it resolve a majority of your problem if you limited the criminal offense to repeat offenders?
I guess that would be one approach. I guess that could be one approach, that it's a fine for.
It would alleviate the problem with the majority of the cases in the public defender, but it would allow you in the case where you have a repeat offender who's coming back to the court, it's becoming a little more serious, and you can have a prosecutor there. Okay, we'll kick it around.
If you had a repeat offender who got a conviction and then went out and did it again, but if the repeat offender that goes to court and the officer doesn't show up, there's no prosecutor there to make him come to court and prosecute the case, or the judge gives the person a probation before judgment if the officer does go to court. So there's so many advantages to having a professional prosecutor look at these cases, screen them appropriately, and only prosecute the egregious offenders, and only seek incarceration, I would imagine, on the egregious repeat offenders.
Okay, thank you.
All right, I think we've done enough here. Thank you very much. concludes the testimony on House Bill 207. We're going to go now to House Bill 125. Welcome to Judiciary Delegate Edelson.
Thank you.
Welcome to the new Judiciary Delegate Rogers.
Can I bring my panel?
Oh, the clerk for Anne Arundel County is here. I don't know. He spends an awful lot of time in the courthouse. I don't know. Mr. Poyer, Ms. Robinson, that's fine. These are the only, Mr. Poyer, it says you're favorable with amendments. Is he strong-armed you into supporting the bill anyway?
There was no strong arm involved.
All right. All right. Well, let's hear from Delegate Rogers, please.
Thank you, Mr. Chair, Madam Vice Chair. For the record, I'm Delegate Rogers, District 32, Anne Arundel County. And I just want to say that it's taken me 5 years to get here. But I made it. So with that, I respectfully request a favorable report for HB 125. This bill authorizes the clerk of the circuit court of each county to keep an electronic record instead of a book for purposes of recording and indexing the discharge papers of a person who has served in the armed forces of the United States. This will aid in the modernization of military records. Service members must voluntarily submit their DD-214 or equivalent for them to be recorded into county records. HB 125 broadens one exception to the mandatory denial of inspection of a discharge record by removing the restriction that it applies only to the relative of a person as specified. This will simply allow the chief clerk to review and provide a copy of the registered document if the request of inspection is made at least 70 years after the discharge papers were presented for recording. Finally, regarding authorized inspections of records, the bill requires a clerk of circuit court to redact the social security number of the individual from any portion of the book or electronic record. So with that, I respectfully request a favorable report of HB 125, and I'd like to turn it over to the biggest, baddest circuit clerk in the state of Maryland.
Well,
Just saying.
I that is the Mr. Chair, that is the best introduction I've ever had, and I thank Delegate Rogers, Chair Clippinger, Vice Chair Bartlett, members of the committee. Thank you very much for the opportunity to testify in support of HB 125. For the record, my name is Scott Poyer. I am the clerk of the circuit court for Anne Arundel County, and I also represent the 24 elected clerks throughout the state of Maryland. The clerks have reviewed the bill, and we had two clarifying comments. The bill sponsor, Delegate Rogers, and the Senate sponsor, Senator Guile, are incorporating the language to clarify on those 2 points. And we are requesting a favorable report on HB 125. I'm available for questions, and thank you to Delegate Rogers for sponsoring this bill.
Yes, thank you, Chairman and Vice Chairman and members of this committee for the opportunity to testify in support of House Bill 125. For the record, my name is Denise Robinson, and in 2016, I founded the Legacy of Honor Project, researching and telling the stories and honoring the men and women who served in World War I and World War II, with an emphasis on the men and women who died while serving. I could list dozens of reasons why access should be granted. The massive fire at St. Louis that destroyed 80% of the personnel files of World War I and World War II service members. But for me, the most important reason is these discharge papers are proof that a veteran is entitled to a headstone provided by the VA. When I first started the Legacy of Honor Project, what surprised me, the number of men and women who had served and who had died while serving that are lying in unmarked graves in our state. I discovered the most common factors of those are the family was poor, they were persons of color, an only child who had never married, or one or more of their parents had died before or shortly after they were buried. All of them were buried before 1955. All the documentation I need to request a headstone, the service number, unit number, enlistment, discharge separation date, and most importantly, the stamp that says honorable discharge is on this one piece of paper. 170, 50 years, I am sometimes the only voice that can get them this headstone. But because of the way the law is written now, I can't access that document, making it more cumbersome for me to prove and place a headstone on a grave. It does not matter if I can prove a service member was awarded a Purple Heart for wounds received on Omaha Beach or a Bronze Star with Valor for crossing the War River. The only thing that entitles a serviceman or woman to a VA headstone is proof of honorable discharge. I urge the committee to give a favorable report on HB 125 so we can honor the men and women who fought and died for our freedom. I would like to thank Delegate Rogers for sponsoring this bill, and I'm available if you have any questions.
You talk about the amendment and what the amendment would do. It's an amendment from the clerks or an amendment with an agreement. So what would that be?
The clerks asked, in the original language, there was a question on whether we would need to redact the social security information immediately, or would we be able to wait until the document was eligible for release? The military did not start incorporating social security numbers until 1969. And 70 years from that would be the year 2039. So our question was, do we need to redact I've got 20 volumes of records. Do I need to do that right now? Or have I got the next 15 years to redact? And we believe the amended language clarifies that we have until the document is eligible for release to accomplish the redaction of the social security numbers. And that's to protect personally identifiable information for any service members that may still be alive.
Seems to be consistent with how I would read it as it stands right now. I don't know if you need to change anything right now, but that's fine. Delegate Crutchfield.
There we go. Thank you very much, Mr. Chair. And thank you, Delegate Rogers, for bringing this bill. My only question is, does this also cover the discharge papers for those who have served in the uniform services as well?
It does.
Okay, because it wasn't explicit in the bill. Thank you.
The vice chair.
Thank you, Mr. Chair, and thank you, Delegate Rogers, and thank you very much, Clerk of the biggest, baddest county in Maryland. Isn't that, you all are great, isn't that so?
I don't need to answer that. All right. Delegate Boucher.
Thank you, Mr. Chairman. Was I correct in hearing that all United States servicemen are guaranteed a grave marker?
If they were discharged honorably, yes. That is one of their entitlements.
I have a bill addressing the Afro-American soldiers that served for Maryland in the Civil War. And as a representative of Carroll County, we have an issue with a lot of unmarked graves for African Americans who served. And I'm wondering, I just want to make sure they should have a marker.
Yes, they should. They're entitled. Yes.
Okay. Colonel, I will talk to you after this about this. Thank you.
Absolutely.
All right, seeing no other questions, thank you all very much.
Sure.
That concludes the testimony on House Bill 125. We're now on the third and final bill, House Bill 217. Delegate Long. Uh-oh. Delegate Long. All right, well, I'll do a little housekeeping and we'll have somebody see if Delegate Long is not long to be here. I'm just killing a little time here. All right, Kevin Ford. Is Kevin Ford here? You're here. I just want to make sure. That's fine. You're testifying in opposition. And Jeremy Zacher, I see over there, he is testifying in opposition. I know we have a virtual person waiting to testify. And so we're calling him. Okay. I dread doing this, but if you all promise to be on your best behavior, we will adjourn for 5 minutes to 1:50 p.m. Give the delegate the opportunity to get here. We'll be back at 1:50. Thank you. All right, ladies and gentlemen, we're going to go ahead and get started again. We have found Delegate Long. If everyone would please take your seats, please. Please take your seats, please. Thank you very much. Again, the House Judiciary Committee on the 24th of January, 2024. This is part 2, where we're doing House Bill 217. This is a bill of first impression, so Delegate Long is going to get 3 minutes. There's one person to testify in favor with him virtually, and that is Vince McAvoy. So we'll hear from him for 2 minutes. So go ahead, Mr. Long, Mr. Long, good Lord. Delegate Long, I'm sorry. Delegate Long for 3 minutes, please.
That's quite all right. Thank you. And please mind my voice. I've had a bout with something, but anyway, I want to thank the chair and vice chair and the members of this committee. For the record, I'm Delegate Bob Long. I'm here representing I want to express my concerns about HB 217 about cannabis use in a motor vehicle while a minor occupant. And if you kind of remember last year when the cannabis bill passed, we tried to amend this on, and because we know that with cannabis, it's new to us and it creates some problems that we really didn't think about. One of the things is, you know, we have individuals in cars smoking marijuana with kids in the back. My wife, well, let me say this. I know from personal experience that kids have shown up to school. You open the door and smokes barrels out. And they couldn't figure out, the parents couldn't figure out why the kid wasn't learning. It's not rocket science. They come to school with a contact high. So we want to make sure that it's clear and evident that it's not okay to smoke marijuana while you're driving or an occupant to smoke marijuana, period. And especially with a child in the car. I know with the new laws that you can't pull somebody over for smells or for the smell of cannabis. I understand that, but this goes a little one step further. You can see someone if they're smoking marijuana in the car. I mean, it's obvious. And you know, that's what it's all about. We want to protect our children. You know, these young children being exposed to marijuana at such a young age cause cognitive behavior problems. We don't know what other effects it'll have. So unfortunately, we do have some parents that thinks it's okay to smoke pot while they're driving with the kids in the car. I think it's unconscionable. That's why this bill was brought forth, so we can protect our youngest kids. And again, please forgive me with my throat.
All right, we'll give you a break for a second and we'll go virtually and hear from Mr. McAvoy. Is he's here? There he is. For 2 minutes, please, Mr. McAvoy.
Thank you so much, Chair and Committee. I want to first thank Delegate Long for bringing this bill. This is something that I had fished around for some help in the summer because of changes that we made here in Maryland. And I was very pleased that not only did Delegate Long pick up the bill, but he approached it from a very innovative standpoint, putting on a transportation article. And I applaud that. I think that's very helpful. As you know, I've related stories. This will be third year on about the harmful things that we're seeing in Baltimore with respect to marijuana. This is a tragedy that we're seeing on the streets. You just heard testimony from city prosecutors speaking to the increase of just lawlessness that has happened post-COVID. I'm sure we all have our theories on that. We'll leave that to another time. But what I want to talk about is that when Delegate Long brings about the unknown aspects of this, of our children being exposed to this wildly increased THC product, that we simply have no way of knowing because we've never had THC products in the 70 to 90% range. And we've never had chronic use such as this. I want to reference this. Historic levels of addiction. The past month in daily marijuana use of marijuana over 20 or more occasions, reached the highest levels ever recorded since they started recording in 1988. And we're having these folks drive. And so I want to close by talking about, for the third year, a story of two mothers driving along around Gilman up on Northern Parkway, two kids in the back with their little iPods, maybe 7, 9, doing their homework The entire thing was like fog traveling on wheels. So I urge you to give a very positive Delegate Long's bill. Thank you all for consideration. Available for questions.
All right, questions? Delegate Williams.
Thank you, Mr. Chair. A really quick question, Delegate Long, thanks for coming to Judiciary. What happens in a scenario where the minor who is in the vehicle has a medical marijuana card and has to utilize marijuana because of some health reason that they have?
That's a very good question. That being said, I don't think that minors can smoke marijuana. I don't think they're allowed, maybe gummy bears or something like that, because I know they do give it to some children that have epilepsy and things of that nature. I understand. But we're not talking about that. We're talking about innocent children sitting in the back of a car while adults are sitting in the front smoking pot.
Right, but the way the bill is worded, I think it would preclude that type of instant situation, even if the minor needed it for medical reasons.
Can you verify? Because I'm trying to figure out.
Yeah, I just wanted to ask a scenario. That was my interpretation of the reading of the bill. And so I just wanted to find out what would your interpretation about what would happen in that particular scenario, because the bill isn't clear.
Right. Well, and I would appreciate this committee working on this. And I know some of the fines we need to work out. But this is a very important issue that we have to address. Again, I can't imagine that a minor child be allowed to have a medical marijuana card, allowed to smoke it. That's just beyond belief. But it could be. I'm not going to say it's not possible.
Okay.
But you know, in this state, you can actually smoke cigarettes while kids are in the car, and it's not illegal. Now think about that.
All right. Thank you.
Delegate Boucher, then Simmons, then Tolles.
Thank you, Chairman. Thank you for bringing this bill forward, Delegate Long. On page 2, line 1, it states an individual may not smoke, vape, or consume cannabis in the passenger area of a motor vehicle in which a minor is an occupant. The consume cannabis could potentially lead to a judge incarcerate someone for consuming a cannabis gummy. Would you be amicable to that language of consume cannabis be stricken from it?
Yes.
All right, thank you.
I thought about that. Believe me, I spent many nights thinking about all the ins and outs, and we want to make sure we get this right.
Thank you, because your objective is to stop people from actually smoking it.
Correct.
All right, thank you.
Delegate Simmons.
Thank you, Mr. Chair. Thank you, Delegate Long. I guess my question would be, currently right now, is cannabis allowed to be consumed while operating a motor vehicle?
No, it's not, but there's two different standards for the driver and for a passenger. Okay. I'm sorry, but if you're the operator of that vehicle, you should be held accountable for what your passenger is doing. Because if you get caught smoking marijuana, I believe this is the way it works. If you're smoking marijuana, it's a $20 civil fine. If you're driving, I think it's a $500 fine plus 1 point. That's not a level playing field. You know, if I'm driving a vehicle, I'm responsible, especially if I have a kid in the back. I mean, it's just common sense. Thank you for that question.
Thank you.
Delegate, does it require the car to be in operation?
Under the Motor Vehicle Act, no, it doesn't, from what I understand. And again, I'm not an attorney. I know it talks deeply about if it's if it's a vehicle that's out for hire under certain circumstance.
But my point is you don't have to be driving the car under the bill. You just simply have to be within a motor vehicle.
Right.
Within the passenger area of a motor vehicle and a youth is present.
Correct. I think that's the same way with alcohol. I don't think you're allowed to sit in your car and drink alcohol. I've never done it, so I don't know.
Okay. Delegate Tolles.
Thank you, Mr. Chair. A few of my questions have been answered. I just wanted to know if, for first Delegate Long, I appreciate the bill. I think it's definitely important to keep our youth, our minors, our children safe from, marijuana smoke in the car. So my question to you would be, could you walk me through how law enforcement would enforce something like this? Have you talked to law enforcement? I mean, like, I think the chair mentioned doesn't have to be in operation. You could just be sitting in a car with the minor. Just tell me what happens. What have you thought about? What different scenarios have you thought about?
The scenarios that I've walked through, whether the car's moving or if it's sitting, if a police officer observes someone smoking a joint, that they should be able to identify that. And when they roll the window down, you'll be able to tell. You can even tell. My wife can smell this stuff 2 miles away. I'm very fortunate I can't. You know, and then if the police officer does pull them over and it's not marijuana, they're not going to be, you know, penalized for it. But if they are, and there's a kid in the car, you're darn right, we need to do something about it.
But the police, so you're saying that, just so I understand, the police would, I don't think it's legal for someone to smoke and drive. So I'm not, that would be illegal. But you're saying if they're sitting in a car, the police can just say, hey, you're not supposed to be smoking with this child. And if they're just sitting in the car, just not doing anything.
I would think that they would be able to investigate. Now, whether they're breaking the law or not, I'm not sure. Unfortunately, like I said, you're allowed to smoke cigarettes in a vehicle.
Correct.
And that's another bill for another day. Because secondhand smoke's just as bad as smoking. So we shouldn't be subjecting our children to that either. Why it's not in law, I don't know.
Okay, definitely needs to be massaged more, but I get what you're trying to do and I appreciate it. I definitely want to make sure that we are being sensitive to minorities in this bill. So I could take that turn.
Right, this has nothing to do with minorities, it has to do with the kids and make sure that they're protected. And I want to thank you for that question. One of the things I really thought long and hard about is, you know, what are the adverse effects of these kids being around us? You know, we can't stop them when they're in a house, it's something else. But if we can observe it in the outside and put some kind of stop to it, or at least give them the education, hey, look, don't smoke pot around you, kid. Look what it's going to do to them in the years. I think it's well worth calls.
Thank you, Mr. Chair. Thank you, Doug.
I want to make sure, because we went through painstakingly this issue of stopping vehicles because of the smell of marijuana, partially because we didn't want public safety officers, police, sheriffs stopping and then searching vehicles because of the smell of marijuana. By making this an incarcerable offense with the stop, would that then give police officers another bite at the apple for doing a search of vehicles and a search of the individuals?
Well, I will leave it up to this committee to come up with what they felt was appropriate punishment if they're caught. And I was there when the marijuana bill passed. I understand if you walk up and you smell marijuana, it's not being digested or, you know, smoked or whatever. I can understand that because now it's legal. But if you're sitting there and you're smoking a joint, I think the police has the right to stop and do something about it. And you're right. I know there was and I think that's where we really got off track. Stopping the police from stopping a car because they smell marijuana. Is it because of them smoking it or the odor of it being in the vehicle? Because if it's in the vehicle, it's not illegal. But if they're smoking, it is. And that's something we need to draw some very sharp lines to.
Yeah, but if they're smoking it, if the driver is not smoking it, the passenger is smoking it, at that point it's not illegal.
Yes, it is. Under there's under Comar, I believe. It's a civil offense and it's only fine. You only fine $20. I think it's a civil offense. Maybe
well, I shouldn't say that. It's not the driver has not committed an illegal offense.
No, but again, I would say that because of smoke and the way that it the nature of it, the driver should be responsible for what goes on inside that car. I mean, you know, you can say, okay, the pastor can sit there and smoke pot and we're only going to give him a $20 fine. The kid's in the back, still not doing anything. So, you know, and hopefully we can come up with a resolution to where we just stop. I mean, I was looking, there was actually a bad accident on 695 where the woman was charged, killed 6 people, and she was under the influence of marijuana. And anyway, getting back to what I was saying, we want to make sure that anyone that's in a vehicle consuming marijuana should be held accountable, especially the driver, because he's getting high too. He might not be holding a cigarette, but he could be getting high. I'm just being honest. I don't know if everybody remembers Cheech and Chong, but you know, I come from that era. It was funny. I never smoked, but anyway.
Thank you.
Delegate Tomlinson.
Thank you, Chairman. So your bill has to do with both somebody consuming cannabis while your bill touches on someone who's driving as well as just a passenger, correct?
Well, I would like to incorporate that because after I read through the information, I realized there's 2 different penalties. And again, this is new for us because, you know, with beer, you know, well, we can go talk about it all day. With cannabis, your neighbor can be sitting next to you, your driver. He's smoking. He's got a big joint and smoking. The car's filled. The kid's in the back. And you're getting high too.
So, yeah, so right now there is no additional penalty for using marijuana as the driver or the passenger while having a minor in the vehicle. I'm looking at our DUI laws, and there's a major additional penalty if you're transporting a child. If I'm looking at this correctly, the first offense of a DUI while transporting a child carries up to 2 years in jail and a fine of $2,000. So they definitely view, as far as drinking and driving, they definitely view it much differently if you have a child in the car.
Yes.
And to me, there is a major difference. Not that drinking and driving with a child is any better, but even if you have a passenger, well, let me ask you this: is it illegal to be drinking as a passenger in a vehicle?
I'm not an attorney, but I believe it is.
It is, yeah.
Okay. Like I said, I'm not an attorney. I've never been caught drinking and driving, so I have no clue.
But whether you're driving or you're the passenger and you're drinking in a vehicle, that's not going to make a child in the back seat get drunk. This is not how alcohol
Right,
works.
I understand. That's why we say we're dealing with a very unique situation with marijuana.
So yeah, with marijuana, it's different. You don't have to be actually smoking the marijuana to get a contact high. Is that correct?
Correct. Well, that's what I'm told.
Yeah. All right. Thank you.
All right, I don't see any further questions. Thank you very much, Delegate, for presenting the bill. We're now going to hear from those in opposition, and I'll ask Mr. Ford and Mr. Zacher to come forward, please.
Well, thank you so much.
Thank you. Hope you
Thanks
feel
for
better.
holding it up. And if you need to find me, I'm always in Ways and Means.
Okay. Mr. Ford is the first person on my list, so with no offense to Mr. Zacher, we'll let him go first. Let's go ahead.
Mr. Chair and esteemed members of the committee, good afternoon. My name is Kevin Ford Jr., and I'm the Executive Director of Uplift Action Fund. Today, I stand before you to request an unfavorable report for HB 217. As a father of 2 boys and a responsible cannabis consumer, I am deeply committed to the safety and well-being of our children. In our home, we strictly enforce a rule against smoking or vaping cannabis and tobacco products around our children, acknowledging the health risks associated with secondhand smoke. However, I have concerns about this bill. According to the Maryland Cannabis Administration website, using cannabis while driving, whether as a driver or a passenger, is already illegal under Maryland law. This existing regulation addresses the primary concern of this bill, making it somewhat redundant. The focus of this bill overlooks the broader issue of all smoke and vapor exposure in vehicles. If the goal is to truly protect minors from the danger of secondhand smoke, then why does this bill not address tobacco smoke, which is equally, if not more, harmful? While on face value, this may seem like common sense policy, by singling out cannabis, this bill risks undermining the progress made in cannabis reform, and could potentially lead to subjective law enforcement practices, which would disproportionately affect Black communities. We must ensure that any further cannabis legislation does not inadvertently perpetuate racial disparities. Therefore, I urge the committee to focus its legislative efforts on measures that genuinely enhance public health and safety without duplicating existing laws or creating potential for unequal enforcement. In conclusion, as a father, I ask this committee to reflect on the implications of this bill We should strive for comprehensive and fair legislation that aligns with our commitment to public health and equality for all. Thank you for your time and allowing me to share my perspective.
Good afternoon, everyone. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City. I work in the juvenile division. I had a lot to say, but actually all the questions that were asked and Mr. Ford here have addressed most of the public defender's concerns. And we do have written testimony that you can read. We're very concerned that this will increase police-citizen encounters. Right now, there is law that prevents an officer from searching a vehicle based merely on the odor of marijuana. Were this this bill to be put in place, the presence of a child may give an officer license to search a vehicle merely based on the odor of marijuana, because it does not prevent an officer from searching a vehicle with the odor of marijuana and a child present. They could use this bill as an excuse for searches of vehicles. And we've heard from Delegate Long that this is primarily addressed at what may be parents bringing their children to school. And the penalties that were discussed were very severe. These are the types of penalties we see for a first offense DUI, up to a year in jail for a parent who may have been smoking or vaping with their child in the back seat. And this is a bill purportedly to defend or protect children. And my experience is that prosecuting parents in this way with such severe penalties, it does not help the child. There are other remedies available. Drivers who are smoking or may be exposed to marijuana smoke, they may be prosecutable under our DUI laws. If a teacher feels like a parent is coming to school with their child and the child is somehow intoxicated, they can contact the Department of Social Services or CPS and file a complaint. There are other mechanisms in place. We feel like this law is a step backwards. Maryland just spoke loudly and clearly in the past few years that they do not want to pursue this war on cannabis and marijuana. And the Office of the Public Defender is asking for an unfavorable. That's all.
Questions for this panel, Delegate Cardin?
Thank you all very much. Two quick questions. First one to the gentleman who spoke first. I forgot your name. I apologize.
Kevin Ford.
Mr. Ford.
Yes, sir.
You suggested that cigarette smoke, tobacco smoke is far worse for children's lungs than cannabis smoke. If you can provide us that data, that would be really helpful.
It's funny. I knew I was going to get that question. I don't have any data with me. I would be happy to provide any studies that I can find to your office, though.
Okay, thanks. And then the second question is, so according to the bill, it looks like may not smoke, vape, or consume cannabis. So the question is, with a child in the car, the question is, if you're using, like, for example, a gummy or something that you would eat as opposed to smoke, that is not going into the child's lungs, wouldn't that be, I mean, I guess this is really for the sponsor of the bill, but wouldn't that be a problem with what the sponsor is trying to tell you, which is that this is harmful to the child? So
I'm not sure.
It's not harmful to the child, couldn't it?
No, I agree with you on that. I mean, I don't believe that, the consumption in any other form should really be restricted. Those are discrete uses. And I think smoking and vaping is really the issue here. We're talking about inhalation, not necessarily consumption.
Okay. All right. Thank you.
Any further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 217. But before we leave, behind in the second row of seats are some people who look suspiciously like the pages. So I'd ask them to come forward. No, you get to come forward to the witness desk, please. You have to come forward. Yes. See if members of the committee have questions for the pages, please. If you have to come up to the table. All right, don't press the buttons, but your microphone should come on. Are there questions for this panel? The Vice Chair.
Who are you and where are you from?
Which order do you want to go?
Start from my right, your left. We'll start with you.
Okay. My name is Jillian Zimmerman. I'm from District 2A and I go to Boonesboro High School. Oh, Western Maryland or Washington County.
My name's Ella Florton. I'm from Anne Arundel County, District 31, and I go to Severna Park High School.
My name is Nikolai Brody. I go to Overley High School in Baltimore County and District 6.
My name is Aaron Robinson. I go to Mergenthaler Vocational Technical High School in Baltimore City, District 40.
My name is Jackson Taylor. I go to Rockville High School in Montgomery County, and my district is 19.
My name is Maggie Slusar. I go to Mount DeSales Academy up in Catonsville, but I live in Anne Arundel County, District 33.
My name's Ava Holloway. I go to Happy Grace High School, Harper County, District 35. My school, my soccer team was awarded a thing in the Senate today for winning the state award. So yeah. That's still my friend in the Senate this morning. So that's pretty cool.
All right, I'm Ryan Cave, District 5, Carroll County, and I go to South Carroll.
Yeah. All right, Delegate Cardin has a question.
I would be curious, you guys are what, 17?
Yes, 17, 18.
I would be curious to know if anybody wants to share feelings on driving smoke.
Not to testify on any legislation. We're not gonna let you get away with that, but what? Good effort.
Yeah, we have to take the jackets off before we can.
That's right.
Yeah.
I could give it a shot.
You tried. Okay, we're not gonna let this go too much longer because, all right, Delegate Williams, please.
After watching the testimony in here, do any of you guys want to be a lawyer?
Yes.
Okay, cool. Kinda. All right.
Yeah.
We feel the same way sometimes. Delegate Boucher and then Schmidt. And then
Thank you, Chairman. Do you have individually a historical hero that motivates you to be in this institution? If so, share it with us.
Oh, I do.
Are you doing?
Yeah, go ahead.
Oh, okay. Kind of convenient for Maryland. My historical motivation would be Frederick Douglass. And I wanted to share a quote by him. He says it's easier to repair broken children than a broken man.
Yeah. I think he's going next year.
I'm personally very inspired by Sandra Day O'Connor, who recently very sadly passed away. I don't have a quote. I'm not that fancy, but I would definitely recommend her book first.
So for me, my late grandpa was involved a lot within the public parks in Montgomery County, and he did kind of a lot of work on them. I know one of the ones, he has a plaque on it that's like a thank you thing for him, and he kind of was my step towards getting involved in this stuff now that I more look back on it.
Only 3 more.
Outstanding. Great. Well, welcome to all the pages. And as we often celebrate the pages in y'all legacy of going on to do greater things, can y'all tell me to one public educator that has inspired y'all to get to where you are today?
I'll go first. But a public educator that has inspired me today, and I might get emotional, is Ashley Bassett. She is the AP government teacher at Boonesboro High School. She is an incredible person. She is, oh my gosh, she's become like one of my best friends. I've had her for 3 years now. She teaches AP comparative too. And she's our 9-time state Meet the People teacher who we've won. And she's just an incredible person and teaches in just such a way that it is like, it just makes you want to learn. Like, you can tell that she genuinely enjoys what she's doing. And so definitely Miss Ashley Bassett from Beechboro High School.
So you can be great and not be a lawyer, is what you're saying?
Yeah.
Who else? Go ahead.
I have two. So my SGA advisor, Christina Bowman, and my comparative government teacher, Sarah Poole. They just really talk to me like I'm an adult, and they like talk to me about real issues. And they just taught me so much and made me feel like I have a voice, and taught me about, power and government. And now I want to do that with my life. So they really showed me.
I have two myself, my 10th and 11th grade networking teacher, Ryan Sigmund, and my 11th grade US history teacher, Katina Harris. We did a lot of work, very tough on us, but they definitely, I wouldn't be where I am today without them, 100%.
Mine would be my law and leadership teacher, Mr. Nicholas McDaniels, who is the Baltimore Teacher Union rep for my school, and also the teacher of the law and leadership teacher, and he's also the attorney coach for our mock trial team, which I am the captain of this year. I'm gonna just make this brief. He never really tells me that I'm great until after I complete something, because he knows that I have a big head. So he's very hard on me to a degree, which has pushed me very far. And I thank him a lot for that. And he was the 2017 Teacher of the Year in Baltimore City.
All right.
Mine would be Krista McKim. She's my debate coach sponsor, and the tie I'm wearing today was actually a gift from her dad, because today would have been my final debate as a senior if I wasn't here today. So this is I told her I won't be wearing it at the debate comp, but I will be wearing it for the General Assembly. So she was fine with that.
It's hard for me to just choose one because I've been so impacted by so many wonderful teachers, but I would have to say my mock trial coach and AP psychology teacher, Miss Barassa. She's really the sweetest. She does everything she can for all of us, and we spend hours and hours and hours on our mock trial cases. We've stayed till like 8 or 9 some nights after school, but she's really inspiring, and I love to go to school and be with her every day.
Mine would probably be my APUS teacher. His name's Mr. Show. I did not think I wanted to do law or politics or anything in this realm until probably this year. I've always wanted to do music. Always thought that was going to be my pathway. But he has absolutely no filter. He says whatever comes to his head, whatever comes to his heart. I see a lot of him in the people that I've met here. But he went to American University, which is I think I'd like to go there. And he's really inspired me to say what I want to say and speak in my truth. So yeah, I think he's definitely put me down a different path.
All right, I gotta go with Mr. Moran and Mr. Widener, both history teachers. I really like my history. For Mr. Moran, he's just got all of US history just in his head. He could just the entire class. He doesn't look at anything. He just 1 hour and 30 minutes. Just straight talking about history, and it's just really impressive. That's exactly what I strive to be like one day. But as a delegate, maybe a senator.
Okay.
All right. Yeah, you're gonna get them all fired up now. Let's not do that. All right, I'm gonna ask the last two delegates to be brief because the chair Hunter's gonna kill me. All right, so Delegate Schmidt, and then we'll go from there.
I have a couple statements of fact here. My seatmate was a page at one point in time. So there is a dignitary here in the house. There was a page. My sister-in-law also teaches at Severna Park High School, so I will not tell her that you didn't say her name here. And lastly, more serious question: who is the coolest delegate?
Delegate Robertson, now, please. Delegate Robertson, please, for his first question.
I know, and it's on the record. And I just want to applaud my delegate mate, because not only is she from District 25, but I also served as a page as well. Greatness comes from District 25. and hope that you enjoy your time and that you take every advantage of this opportunity. And just for these fellow delegates, some of you might serve on the Senate side, what is it like when you see the buttons light up and you're called and don't realize where you have to go to deliver your coffee or water? If you want to briefly tell them how they can be nicer.
It's a trick of the trade. We're gonna let them keep that. They can keep that secret.
Thank you all.
Isn't that so, is what you meant to say. Anyway, so we thank you all very much for being with us. We thank you all very much. What was that?
This is not related to the pages, but I did want to, if I could.
Briefly, yes.
Very brief. I am very excited because I have a new intern, Mr. Jamel Freeman, who's been
I
sitting with us the entire time. Stand up, Jamel. Jamel is from Frederick County, Delegate Simpson's district. But I would suggest to all of you, he's an author, wrote a book called I Can Do This. Ask him why. Can I do this? Ask him why. So that's all. Thank you very much.
Thank you all very much. Thank you very much for the pages, for letting us grill you for a couple minutes. We'll be back tomorrow at 1 o'clock. Thank you very much.